Our last lesson is going to discuss trademarks, patents, and copyrights. If you are looking to sell on Amazon in order to become a branded content seller on Amazon, you have to have one of these three. Now, let's start with trademarks. So a trademark is a recognizable sign, design, symbol, or expression used to identify and distinguish the goods or services of a particular source from those of others. It is a form of intellectual property that protects the distinctive identity of a company, product, and helps consumers recognize and distinguish it from other products or services in the marketplace. So this is going to be your Nike check mark and the slogan, "Just Do It." Trademarks can include words, logos, slogans, and other distinctive designs or symbols that are used to identify and distinguish a brand. They can be registered with a government agency such as the United States Patent and Trademark Office to provide legal protection and prevent others from using the same or similar marks without permission. By obtaining a trademark, a company can build brand recognition, establish a reputable, and differentiate themselves from competitors in its market. It is also the company to take legal action against others who use its mark without permission, preventing confusion among consumers and protecting the company's reputation and brand value. It is just a level of protection or a type of protection if you trademark your company logo, your company name sometimes, depending on what the name is, or if you have a unique, slogan. Now let's talk about patents. There are a variety of types of patents, but a patent is a legal document that gives the holder exclusive rights to an invention for a certain period of time, typically 20 years from the date of filing the patent application. A patent grants the inventor the right to prevent others from making, using, selling, or importing the invention without their permission. To obtain a patent, an inventor must file a patent application with the relevant government agency, which includes a detailed description of the invention and how it works. The application is then examined by a patent examiner who determines whether the invention is novel, non-obvious, and useful, and whether it meets other legal requirements. If the patent is granted, the inventor can license the technology to sellers, sell the patent to a third party, or use it themselves to manufacture and sell the invention. Patents can be granted for a wide range of inventions, including machines, processes, compositions of matter, and designs. Now, I do want to say one thing. If you plan on filing a patent specifically, I highly recommend getting a patent attorney because the process has become extremely more in-depth to file a patent. There are utility patents, there are a variety of different patents. And then if you intend on essentially selling that patent or letting others use it, so let's say you created a really cool process, a really cool computer chip that can be put into phones, you can let companies like Apple and Microsoft use that patent and pay you a royalty. So there are tons of things that go into that, and if whatever you intend on using that patent for, it's good to talk to a patent attorney in order to determine how you need to file that patent. The last thing I want to cover is a copyright. A copyright is a legal concept that gives the creator of an original work exclusive rights to control the use and distribution of that work. This includes the right to make copies, distribute, perform, and display the work publicly. Copyright protection applies to a various type of creative works, such as literary works, music, photographs, software, and movies, among others. Now, a lot of your, favorite songs, top 100 songs, a lot of those record labels will patent the music and the beats and sometimes even the lyrics. And this is where a lot of the legal battles come in, because you'll hear a song that has a similar beat, but because the copyright was for a very specific form of music, if that beat has one additional, tone in it or whatever, it's not eligible for a lawsuit because technically it's different. And there's a lot of cases with this, and you can go back and I'm sure you can think of a few. Now, the purpose of a copyright is to incentivize and protect creativity by allowing creators to benefit financially and legally from their creations. Copyright protection is automatic and applies as soon as the work is created, but it is advisable to register the work with the Copyright Office to strengthen the creator's legal rights and ability to enforce them. Copyright protection generally lasts for the life of the creator plus a certain number of years after their death, depending on the country where the work was created. So if you copyright a piece of music, it sticks with you till the end of your life and then maybe a few years after. So you'll see that when a lot of artists pass away, we'll have a lot of these these unreleased albums come out and things like that, and that's because the copyright for that property has now ended. Again, definitely go to a copyright office and speak to a copyright attorney. There are attorneys who specialize in these things, protecting them and filing for them. So it's a really good idea to really put this together with someone who knows what they're doing, because copyright laws change all of the time. It's so hard to keep track of unless it's your actual job.